for fraud, the speech is integral to the crime. That is the crime, the speech. So where do you draw the line? Fraud doesn't implicate the First Amendment, but this does. But so where's your line?
That's a good question, Your Honor. The line is, and if we look at the same case before that I was mentioning for historically unprotected speech, U.S. v. Alvarez, we can see fraud is another one of those pieces of speech that falls under historically unprotected. The difference between fraud and what Jenkins is doing is that fraud, number one, it has to be obviously false. It has to be misleading statements. And number two, there has to be a legally cognizable harm that goes along with it. That's really what allows the government to regulate it. With Jenkins's speech, there has been no legally cognizable harm on the record.
Isn't the statute have the harm already in there that with the intent to impede the election?
Well, Your Honor, the statute requires that someone has the intent to impede, but the statute doesn't require that that effect actually comes about. So it might be that someone releases information with the intent to harm the campaign, but ultimately it falls flat and that doesn't actually happen. So no, the statute doesn't require a legally cognizable harm in it.